To this training on affordable and fair housing policies. I am Kathy Hunter, and I chair the Woodbridge Housing Committee, and I'm also a member of the Planning and Zoning Commission. Just for housekeeping, this is required training for land use officials, so we do have separate sign-in sheets. I don't know if you noticed that when you came in. If you're on Woodbridge's Planning and Zoning Commission or the Zoning Board of Appeals, there's a separate sign-in sheet. And if you happen to be from the Squad area, there's also a separate sheet for you, and you could indicate your town, and I'll make sure to get that over to the Squad office, so you get credit for your training. And if you're just a resident or another commission, there's also a third sign-in sheet you could sign in. So first of all, I would like to thank the JCC. I'm not sure if anybody here from JCC is here tonight, but for hosting us in this really beautiful space to provide this training. The JCC has always been such an amazing partner in our community, and we thank them. So with that, I'd like to introduce our presenter, Attorney Mark Brins. Mark Brins has over 40 years experience in land use and environmental law, and has provided legal services to land use agencies in over 2 dozen municipalities, representing applications and neighborhood associations in over 70 towns. He's currently an attorney at Heller and Sage, and he's been very busy doing these trainings around the state. And I have to say, I did have the opportunity to watch this particular training that he's going to do tonight, and it's excellent. And I think you're going to find this extremely informative. So with that, Attorney Brins.
Thank you, Kathy, and thank you for having me here. I'm a member of the Planning and Zoning Section of the Bar Association, and we make speakers available to municipalities and other groups that request them. We do that at no charge as long as we can fit it into our schedules. So I'm glad to be here. As Kathy noted, this does count towards your Public Act 2129 requirement for fair and affordable housing and education, and I know it's being recorded. In addition, you see these slides all say clear on the bottom. It's Connecticut Land Use Education and Research, which is part of the University of Connecticut, and they offer training sessions in a number of topics for members of land use agencies, including wetlands agencies, and they have ongoing training. We just had one on Saturday, as a matter of fact, it's sold out. There will probably be another one on December 9th, at least that's what we're targeting, and that will be on a number of topics as well. So let's talk about fair housing. Some of these slides, by the way, came from Clear, some are from Mark Shansky, very capable land use attorney in the Navy, and some of you quoted out of Connecticut, and they were kind enough to let me use these for this
Can you
presentation.
speak up a bit, please?
Sorry?
Can you speak up a bit, please?
I'll try to talk more into the mic, but I will tell you, I have vocal cord problems. I always will. So if you're having trouble hearing me, move up. If I get too close to the mic, you're going to get that funny sound, right? So if you move, come on up. Like I say, come on down. And you can say, I know it's a big room, it's hard to fill, but especially, I did all day course, 8 hours of lecturing on Monday, 8 hours on Wednesday, and 4 hours on Saturday. So my voice is not quite what I like it to be. So by all means, please move up if you're having trouble hearing me. Connecticut faces a dual housing crisis. We're one of the most segregated states in the country, and we have some of the highest housing costs. That combination creates some unique challenges for us. You can see, I know you can't read these maps easily from where you're sitting, but again, I'll make this PowerPoint available to Kathy so you can post it or otherwise share it if you like. That dark blue is the degree of segregation. You can see many of the New England states are highly segregated, and the red is the highest housing cost. And of course, Connecticut, New York, all of New York are very, very expensive areas to live. We're the 10th highest in the country for housing costs. And what's called housing insecurity is widespread, and I'll talk about that more shortly. 28% of Connecticut residents reported that it's slight or no confidence that they can make next month's rental payment, just next month's. And in 2018, 26% of renters spend over 50% of their income on housing costs. Now, we'll talk a little bit more. We talked about a family who has to work in Connecticut has to work 79 hours a week, 2 40-hour jobs, at minimum wage to afford rent for a 2-bedroom apartment on the private market. That's one of the highest rates in the country. As we know, a lot of people don't earn even the minimum wage. So if you have a husband or wife both working minimum wage, 40 hours a week, they can't afford a 2-bedroom apartment in the state. What is affordable? Any of you that have ever applied for a mortgage know the drill. The bank looks at your income, they look at your W-2s, they look at all your information, and what they want to know is that you can afford to buy that house, mortgage payments, insurance, taxes, everything else, at 30% of your income. No more than 30% of your income. That is the standard throughout the country. Every bank knows that if you're paying more than 30% of your income for housing costs, that you're stressed in terms of money for other things, food, transportation, fuel, things of that kind. And that's why a bank won't even give you a mortgage if the house you're buying is going to exceed 30% of your income. And yet, if you look at people at 80% of average median income in this state, 376,850 households, that's not people, that's households, are paying more than 30%. And another 208,000 are paying more than 50% of their income. That means they don't have enough money for health care and many other things that are vital to them. They're being forced to make choices that are difficult ones and that have ramifications for society. Poor performance in schools, absenteeism from work, health issues, many things that have societal costs. And you can see that below 30%, people at below 30% of the median income, you're talking 168,000 households that are in that category, and at over 50% at 135,000 households. So there's a lot of people who are in this pickle. We talked about it being one of the most segregated states. Where do these patterns happen? A lot of people assume, and I always did, frankly, that patterns of segregation in New England have occurred sort of by happenstance. That because income and race correlate in this country, always has to us, that areas that have higher income tend to be more white. Areas of lower income just tend to be black. There's an excellent book that any of you should read called The Color of Law. And that book describes how these patterns are in fact reflections in many cases of government programs, U.S. government programs, and specific requirements, historical requirements. You see here, you can't read, of course, there's a copy of the deed from a subdivision in West Hartford from 1940. And what it says is, this is high-ledge homes. Sounds like this. They are conveying these lots, under this condition, no persons of any race except the white race shall use or occupy any building in any lot, except this covenant shall not permit occupancy by domestic servants of a different race employed by an owner or tenant. These kinds of restrictions were very, very common, and there's a reason why they were common. And the reason is because the Federal Housing Administration and the Veterans Administration required them in neighborhoods where they would issue mortgages. So stop and think about this. If you were a veteran, a black veteran, you could apply for a VA mortgage, and you would get that VA mortgage. But under the rules of the VA, you could only use that mortgage in a VA-approved development. And the VA would not approve development unless it excluded blacks. So the mortgage you had was worthless. The same was true for Fair Housing Act, for Fair Housing Administration. They required these restrictions in the communities that they financed. A lot of you may have heard about Levittown, huge development in New Jersey. The Levitts at first refused to impose these restrictions, and were told by FHA, if you do not include this, we will not approve your development for FHA mortgages. I'm sure most of us are in a situation where our biggest asset is the equity in our home, People after World War II, using these FHA and VA mortgages, began to build equity, buying houses in this part of that suburban boom. Blacks were excluded from that trade. They weren't allowed to get on that. They could not buy, at least not with FHA or VA mortgages. So that wasn't just happenstance. The reason, by the way, that was in the law was because Roosevelt thought that home ownership was important. He knew that people returning from the war would want to buy homes. He wanted to get this program approved, and the Southern Democrats would not approve it unless it included this provision. So it's right there in the federal law that FHA and VA could not issue mortgages in a neighborhood unless it excluded black people from living there. Note, it was okay if they were domestic servants, but not as owners. Also, there's something called redlining. I'm sure you've heard about this. Banks used to, now it's illegal, but banks actually used to designate urban areas, largely black areas, as areas where they would not issue mortgages. So if you wanted to buy in white or black, if you wanted to buy in an urban or black neighborhood, the bank simply would not give you a mortgage. And so that also fed that what's called the white flight to the suburbs. Those areas you could get financing for. It also is one of the reasons why you have such high rates of landlord tenancy in urban areas. If you were wealthy enough to just buy the property and own it, then you would rent it out as an income property, as a commercial property. But if you wanted to buy it as a dwelling, as your own home, you couldn't get the financing because of rent law. So where does zoning fit in all this? In 1926, the United States Supreme Court issued its decision called Euclid versus Ambler Realty. This case held that zoning was constitutional. There's a great line in Euclid versus Ambler where the court says a pig in the poke is not the same as a pig in the parlor. That there are appropriate places for things, that you should be able to separate commercial areas, industrial areas, single-family areas, multifamily areas, so that you don't have conflicting uses. And that is logical, and of course that's one of the reasons why so many towns do have zoning, to try to separate those incompatible uses. But it ended up sort of going amok. The courts construed zoning very broadly, and including relative to race. This is a federal district court decision where the Judge Westenhaver, said in district court, I quote, "The blighting of property values and the congestion of population wherever the colored or certain foreign races invade a residential section are so well known as to be within the judicial cognizance." The judge is basically saying everybody knows that there's blacks in your neighborhood and things are going to go downhill, so we're going to uphold zoning regulations that prevent that from happening. That led to patterns that we still see today. You can see the blue line is the income level for whites between 1983 and 2024. It goes up and down, and then you look below and you see for black and Hispanic, much lower and without much rise either during that same period of time. Wealth and race have become correlated in this country, again, not just by happenstance, but by programs of banks and government. Another way to view that connection between segregation and housing, people who have less than 30% of median income are 10%, or over 10% white, almost 27% black, over 30% Hispanic. One of the things that the Growing Together Connecticut did was to map what they called opportunity zones. They looked at all the towns in Connecticut, and they looked at various factors about those towns. One they called broadly education. They gave 33% weight for that, and that's the rating of the school system, median income. Then they looked at employment. What sort of job opportunities were there in these towns? How accessible were they to good jobs? What sort of job growth was there? And then they looked at what they called neighborhood factors, another 33%. What's the crime rate? What's the percentage of home ownership? What's the poverty rate? And out of that, they mapped areas of high and low opportunity. That is to say, areas where if you moved there, you would have a good chance for a good job, your kids would have a chance for good education, you would have access to cultural opportunities, to good transportation, all the things that make families productive and make people successful, both financially and socially. There's your map of the highest opportunity areas and the lowest, very lowest. And if you study this map carefully, you will see that the urban areas are low and very low, and the suburban areas are high and very high. And that's because it's a cycle. As towns become wealthier, more affluent, they become whiter because of the correlation between race and income. Then when you put race, the blue dots are concentrations of racial minorities, of Black and Hispanic, and you see they fall predominantly in the areas of the lowest opportunity. So people who are already starting out behind the 8 ball are kept behind the 8 ball because they're unable to live in communities where they have the highest opportunities for jobs, education, and other things that will allow them to improve their lives. You'll see here that the white living in those say very low opportunities, only 7%. But 47% of non-Hispanic Blacks are in very low opportunity areas, 43% Hispanic, and 13% Asian. So again, that correlation we talked about. Let me go back that slide. 3% of Connecticut's land area is located in very low opportunity areas. And yet, you have 47% of the non-Hispanic Black and 43% Hispanic in that 3%. So we have concentrated the lowest income people in the lowest opportunity areas and left the other areas as higher opportunity, but out of reach. The government also has reinforced this pattern with public housing. One of the things that is in Connecticut law is that a housing authority cannot construct housing outside of its own municipal boundaries. So for example, the Hartford Housing Authority can't propose a housing development in West Hartford, East Hartford, or Glastonbury. It has to be Hartford. And state and federal governments have given a lot of money to housing authorities to build low-cost housing in areas that are already low-cost and already low opportunity. And so you see the blue dots show you where those public housing projects are located, and again, they're in those same areas that we keep seeing over and over again. The areas with least opportunity with already the highest concentrations of minority populations. Makes it very easy also to cut funding for those, for education and other things in those areas, because they don't have the money, and money is power. Probably all countries. Where does zoning fit into this? We have fair housing laws, both federal and state have what's called the Fair Housing Act. There's both a state and federal version of this that prohibits discrimination. So those redlining practices that you saw, those have been illegal for a number of years now. So at least we have that. But the patterns that they created are still here. The Zoning Enabling Act 8-2 and then the Planning Enabling Act 8-23 have, for the last 50 years, said that towns must encourage the development of multifamily dwellings and that they must promote housing choice and economic diversity, including housing for both low and moderate income households. So the zoning power that towns guard so zealously included in it from the very beginning that besides separating commercial and industrial uses and providing for proper transportation and so on, from the very beginning, zoning laws were supposed to be planned for the needs of multifamily and to provide for low and moderate income housing. And yet it simply has not happened. And it's not just any one town. This is across the entire state and really across the country. Connecticut's Constitution says that no one should be deprived of equal protection of law because of religion, race, color, ancestry, or national origin. So on the books, we're all equal. On the books, everyone's supposed to be treated the same. The pattern, as you see, is simply not reflecting that. At 8-2, this is really, I mentioned this earlier, it specifically requires it. By the way, you don't have to have zoning. Towns aren't required to have zoning. Two towns in Connecticut don't have zoning. But if you have zoning, you're required to provide opportunities for multifamily dwellings to consist with the soil types and terrain. But yet, they don't. Sorry. So one of the state is trying to come up with some remedies for this. One of them, I know you're all familiar with it, is 830G, the Affordable Housing Act. And I'm going to review with you what that does to the typical process. By the way, there's two kinds of affordable housing developments. One is what's called assisted housing. Don't confuse that with assisted living, people who are disabled or elderly or whatever. We're using the term in a different way. Assisted housing is housing that is receiving some kind of government support. It may be a CHFA guaranteed mortgage. It may be a Title VIII voucher. It may be your own public housing authority. It may be deed-restricted units that are privately owned and managed. All of those count as what's called assisted housing. So that's one type of 830G affordable housing that some of you may see. The other, the one that you definitely will see, have seen already, is called the set-aside development. This is where a private developer agrees that 30% of units will be deed-restricted for 40 years, and of those 30%, half of them, that is 15%, will be rented or sold at prices that will allow someone at 80% of the median income to buy or rent without spending more than 30% of their income on that housing. The other half, that is the other 15%, has to be restricted to those at 60% of the median income. In exchange for this, the developer gets to basically, so the developer submits an affordability plan, has to designate who the administrator is. I'm not your attorney, but my personal recommendation is that the town should always be the administrator. Developers like to be the administrator, but remember this. You're asking a private developer to collect less money in rent or less money on sale in order to meet the affordability plan. People just don't do that. I wish they did, but they don't. I do have a client who does, I will tell you, but unfortunately most of them do not. So if they can get away with it, they will. I've just been retained by, I'll tell you the town, this is public information, it's out of Colchester. Colchester had an 830G development come in. It was a single family development. It required 7 affordable houses out of 23 units. And the developer has sold all the market rate units. Now all that's left are the 7 deed restricted units. And now he is trying to sell them at market rate. And he said, well, I don't have to sell those to 80% and 60% median. I haven't yet figured out what his explanation of that is. Can't wait. So I personally think that the administrator should be your housing authority or some other agency. And by the way, there are private agencies that will do this for a fee. There's a question? Oh, no, I'm sorry, I thought it was a question. Right. The units have to be distributed throughout the development. You can't group them all in one spot, so that once. And they have to include a sample calculation of how the rents or sale prices are determined. The units have to be comparable in workmanship. So, for example, workmanship and other factors. So, for example, the developer can't say, the 30% of my apartments that would be deed restricted are the 1-bedroom units. And then all the 2 and 3-bedroom units would be market rate. You can't do that, right? The units have to be comparable in size, in bedroom count, they have to be distributed. You can't segregate them within the project development. And you have to provide what your rules and regulations are, and sometimes a conceptual plan. So let's compare an 830G development to your typical application you as zoning commissioners. But how many of you are on the planning commission or zoning commission combined? Okay, so you have 7 that are on the commission, right? In a typical application, the applicant has to comply with the zoning regulations or the subdivision regulations. In a set-aside development, you can take the zoning regs and the subdivision regs and just throw them up. There's no zoning. Zoning does not apply, subdivision does not apply. Wetlands still does, which is a problem with zoning, but anyway. Second, in a normal case, the applicant has the burden of proving that they comply with the zoning or subdivision regulations. And in 830G, the commission has the burden of proving that the decision to deny or condition the development is necessary to protect and quote a substantial public interest. The word substantial is right in the statute. And it has to be a substantial interest in health, safety, or the language says other matters that the commission may consider. That other matters category has been very narrowly construed by the courts. Environmental factors do count. Coastal area management does count. Beyond that, I haven't seen much of the courts are willing to accept in the other matters category. So basically, it's health and safety. It has to be substantial. It has that substantial adverse impact on health and safety has to outweigh the need for affordable housing in the community. So if the town is at 2% affordable housing, the burden is a lot heavier than if they're at 8 or 9% affordable housing. And lastly, in a typical situation, when you act on an application, you can approve it if you feel that it complies with the regulations. You can deny it if you feel that it does not. Or you can modify something that's wrong with it and fix it. You can, but you don't have to. You could say, this doesn't comply, deny it, and they can come back. In an 830G, that is not the case. In an 830G, if you can fix it, you have to fix it. All right? The idea is not to come up with straw men and try to shoot them down. Another aspect in a typical application, the commission is supposed to state its reasons for its decision. It says in the statutes, the commission shall state the reasons for its decision. The courts have said that that shall is what's called directory rather than mandatory. If you don't do it, no problem. In a 830G set-aside development, the commission has to state the reasons for denial. They have to state what was that substantial adverse impact on health and safety that justified denial, and it has to be specific. Next, in an appeal of a typical application, the court searches the record to find evidence that supports the commission's decision. In an 830G, the court is required to conduct what's called a plenary review. They look at all the evidence and see if it justifies the decision. In a typical situation, the court, if they find that the commission has acted improperly, they will overturn the decision and remand it back. Or they'll say they sustain their burden and the decision is upheld. But in an affordable housing application, the court has more options. It can remand for partial items. It can itself modify the application, which would not happen in other types of applications. Another difference, in a typical situation, if an applicant is denied and feels that they've been denied wrongly, they have 15 days from date of publication within which to appeal to Superior Court. That's their only option. If they don't appeal within that 15-day period, they've given up any claims that they may have had of the commission's impropriety. But in a set-aside development, if it's to deny or approve the conditions to which the applicant objects, they have that same 15-day period within which to go back to the commission with a revised plan that addresses those stated reasons for denial. Now remember I said, the reasons for denial, commission, have to be very specifically stated. So that allows the developer to say, okay, now I know exactly why they denied me. I can fix those items, and here's how I'm going to do it, and go back. If there was a public hearing on the original application, there must be a public hearing on what we call the second bite of the apple, right? And that's the term that really is used to describe it. So the deck is deliberately stacked in favor of the developer, and no mistake about it, that's how the law was written. It was based on the law in Massachusetts. It was on the books already with some tweaks. And we talked about that they can appeal directly to the court or they can bring in a modified application. That modified application, when it comes back, the commission is limited to looking at the grounds for that they denied on. It's not a whole new open season. The commission does not get to start all over again with all new evidence and all new reasons. They are confined to the reasons that they provided in round one. Those are the only ones that they can use in the second round. There's a question here.
On the previous slide, I think so on the bottom where the blue box is, the application and sitting up with it, does it say 15 or is it 150 after set aside?
Can someone repeat that for me? I can find it.
15 is can't read the bottom line.
On the bottom line. Oh, yeah, if the application provided for improved conditions, the applicant filed a modification to the application within 15 days of the date of publication. All right. If, so they can return again for this second round, and the commission has to make a decision within 65 days of the date of receipt. If that second proposal triggers some kind of wetlands activity, some new wetlands activity, the applicant must go back to the Wetlands Commission and get that approved. I did have this happen actually in the case of Fairfield, where the commission denied for two reasons. One was that they said the fire truck turnaround that was proposed came in too late, and they didn't have time to review it, and so they denied it. Now, mind you, the question about the fire truck came up 24 hours before the public hearing, the final public hearing. But the commission said, oh, well, you responded to our concern, but too late. And then the second thing was that there was a question of whether a shoulder, a reinforced shoulder, should be placed on the entrance driveway. So the court remanded it back to the commission to look at those two items and only those two items. And the applicant had to go to wetlands because that reinforced shoulder was in the upper review area. So they had to go back to wetlands, and the wetlands to approve the reinforced shoulder for the driveway that the commission had already approved, and then back to the commission. The commission, instead of confining themselves to those two items, treated it as a whole new opportunity to review the entire application, bringing all new experts, all new issues, etc. And Fairfield is now being sued for about $3.4 million for doing that, because the court's order was clear. A trial court has already found that Fairfield operated in violation of the court's remand, and now we're down to what's called the hearing of damages. How much does Fairfield have to pay? Not anything, but how much? And that's where the haggling is going on right now. And I already mentioned that there was a public hearing when it came the first time. There has to be a public hearing on this second round. The towns that are subject to A30G are ones that have less than 10% of their housing classified as affordable. Affordable consists of anything with government assistance. So your public housing, your CHA mortgages, which is next, your title, your Section 8 vouchers, units for the set-aside development that are deemed restricted, mobile home parks count, and accessory apartments count, as long as they are deemed restricted at 80% or 60% of the income. So they still have to be deemed restricted. The exception to that is an occupant-owned mobile home park that is a co-op. All the units count as affordable housing. Right? One of the things that, I don't know if any of your towns have mobile home parks, but mobile homes tend to rent or sell within affordable housing limits anyway. And I know that some towns have tried to negotiate with the owners of mobile home parks to ask them to put a deed restriction on some or all the units so they count toward affordable housing, and often in exchange for some sort of tax break. State law does allow towns to give property tax abatements for deed restricted affordable housing. You're not required to, but you are allowed to, and that's an incentive that you may be able to use. The other thing I'll mention to you, and again, not as your attorney, but just what I tell my own clients, it's my recommendation to my client towns, if they allow accessory apartments, many towns, like most towns do, that you require them to be deed restricted affordable. First of all, they usually rent for affordable rents anyway, because they're usually small, tacked onto a larger house. And second of all, if you're going to have that increased density, get some credit for it. Get some points towards your 10%. Why not?
Question?
Yes.
Do you know a town in Connecticut that has a tax abatement program that is working successfully?
I understand, I know that Northstone did study it. I'm not sure if they adopted it. And I also know that, I think Fairfield has it on the books, but I don't know if they've approved any under it. I know they have the ordinance. Yes. And by the way, for accessory units being deemed restricted, the town of, I drafted regulations in the town of New Hartford that will also be considered an Andover, where they allow accessory apartments by special exception, public hearing, etc., etc. If they're not deemed restricted affordable, but if they are deemed restricted affordable, it's allowed as a right. So the hope is that rather than go through all the special permit and hearing and all that red tape, people like to just walk down the zoning option and get approval, but then they have to deem restricted. So that's another option that you can use. Towns have had over 30 years to comply with this 10%. It's not new, folks. It may be new in your neighborhood, but it isn't new on the books. And the idea is to use private enterprise, to use the profit motive to provide expanded housing opportunity. I've been at so many of these hearings, and you'll always hear someone say, the developer's only here to make money. They don't care about affordable housing, they're just here for profit. Yes, that's exactly right. That's how the law is supposed to work. We are, after all, a free market economy, at least we like to think so. And the profit motive is, in fact, what makes America go around. So yes, the developers are there to make money. They're not there to have their businesses, some are, most aren't. And the idea is to harness that profit motive to generate housing. Let's talk about it, okay? There are certain exemptions to 830G. One is if your town is already at 10% or more, and you're not subject to it. If the set-aside development, notice set-aside, not assisted, so if it has government money, don't listen to what I'm about to say, but if it's a developer set-aside, private set-aside development, it's not allowed in an industrial zone where residential uses are prohibited. Now, I will tell you, the appellate courts have not interpreted this exemption. And there's a lot of question about how it is actually applied. One Superior Court judge, in other words, Superior Court decisions are not binding on other courts. They are only binding on the parties to that case. But one Superior Court judge said that the zone has to have the word industrial in its title. The statute doesn't say that. I don't know where the judge got that, but the judge decided that it was, in this case, it was called like employment zone or corporate park zone or something like that. The judge said, well, it doesn't have the word industrial, so it doesn't count. Makes no sense to me, but that was one court. Another argument that has been made for this exemption is that if the zone allows a university, that's a residential zone, residential use, because universities might have dormitories. Another argument is that if your industrial zone allows hotels, that's a residential use. I don't think so. I don't think a hotel is a residential use. I think it's commercial use. Another argument is that if your industrial zone allows houses of worship, that's a residential use because it might have a rectory or a parsonage. Yes, it might. We don't know how those arguments will hold up. No court has really ruled on that. So just be aware of those questions that are out there. Another option is fairly recently after the adoption of 830G was the ability to apply for a moratorium. A lot of towns that were at 2% or 3% affordable said, you know, what's the point? We'll never reach 10%. Why bother? Why even try? And so the General Assembly amended the Act to say that if you make 2% progress toward your goal, if you get 2% more affordable housing in your community by housing authority or set aside or however you do it, then you can apply for a moratorium, for a break that lasts for 4 years. So 4 years of breathing time when no 830G can be filed in your town. If during that 4-year period you go 10% more toward your goal, you can get another 4 years of moratorium. As far as we know, you can only get 2. I think West Florida's gotten 2. Not many towns have gotten even 1, let alone 2. But the statute seems to be regularly saying that you can only get 2 of those 8 years of exemption. And obviously the idea is that during that 4 or 8 years, you'll use that opportunity to get your next 2%, or your extra percent after that and make some progress and have that breathing space. You notice the last 5 years, the town had a previous moratorium, it was more than 20,000 dwelling units. Obviously, there was a carve out for some town or other that had a powerful legislature. How it works. But the moratorium does not apply, again, for the government-assisted units at 60% of median. Assisted housing is in 40 units or fewer, or of course, an application filed before the moratorium became effective. And I'll tell you right now, there are a flurry of applications in towns who are applying for the moratorium, where people are trying to beat the approval of the moratorium. That does happen. But that does give you some incentive to at least make progress toward your goal. The other thing I will tell you, it's not on the slide. I mentioned to you that when the court reviews this, they look at the need for affordable housing in your community. And if you read that in the statutes, it sounds like it's a matter of percentages. You're 2%, 8%. But that's not really what happens. I tell young associates, judges are human, you know, that's why they're not computers. And the fact is that if a court sees that you have approved 830G applications, they are more likely to cut you some slack when you deny one. So, and I know that, for example, Westport argued that in an 830G defense. They said, look, we approved 3 of these. And that wasn't it. I mean, the judge did consider that. Moral of the story for you, if you can approve it, approve it. Okay? It just put you in a better position when the one comes along that you just can't stand. Right? So, do your best. I know the crowd is out there yelling. Do your best. We're not going to do the question and answer stuff. There are alternatives to 830G. Let's talk about what those are. There's something called incentive housing. A friend of mine calls this the kinder, gentler 830G. It's just a little less onerous. First of all, one of the objections to 830G, and a justifiable one, is that it's the antithesis of good planning. Now mind you, your plans of conservation and development have been required for decades to address multifamily housing and housing opportunity, even though they don't. But be that as it may, in an 830G application, the developer basically picks a spot that they think they can make the numbers work for affordable housing, and that's where they propose it. May have no correlation to the planning that your town has done for its growth. So it is the antithesis of good planning. It is ad hoc land use. And as a former town planner, I tell my lawyer friends, I used to have an honest job as a town planner. I have a master's in state and local government, and I was a planner for about 5 years. But then every time I turned around, there was a legal issue. So I went to the federal poverty level for 3 years and went to law school because I wanted to witchcraft myself. But anyway, so this was an alternative. This provides state grants that the funds are available for towns to plan for where affordable housing belongs in their community, where they want it to be. So it's not reactive. It is good planning. The problem with this law is that it sets very high minimum densities. 6 per acre for single family, 10 per acre for duplex townhouses, and 20 per acre for multifamily. Interestingly, the Connecticut Home Builders Association, which usually loves anything involved in development, objected to these densities. They said, these are too dense, too high. Our members don't build at these densities. We're not familiar with how to do it. And of course, in many towns, you don't have the sewer and water to support densities like this. So unfortunately, this has not been used to the extent that it should have been and could have been. If a town is less than 5,000, they can ask the Department of Housing to allow slightly lower densities, 4 per acre single family, 6 per acre duplex townhouses, 10 for multifamily. Those are still pretty high densities. Many towns did take advantage of these planning grants. I worked with Hebron and Coventry and Haddam, and they did designate some locations. Other problems with this program were the way that the Department of Housing administered them, and I won't get into that. But this did not fulfill its potential, in my opinion at least. You mentioned here that high density requirements can make it hard to ID locations. The town of Haddam is about 55 square miles. They hired a very competent engineering firm to evaluate the entire town to try to find one spot where they could support even these town less than 5,000 density, and they could not find single spot in the entire town where residences will be supported. So that law needs to be revisited, I think. Other things, accessory dwelling units, I talked about that. Most of you do allow them. You could require that they be, you'll have to opt out, it's called opt out of the state statutory mandate that prohibits this, but you can do that, you're allowed to do that. And you could say that those have to be deemed restricted to the 60% or 80% median. You can allow density bonuses. You could say that this zone allows 1 per acre, but if you include a certain amount of affordable housing units, we'll give you density bonus. Again, giving the developer a dollar incentive to include some diversity in the housing stock. Something called the missing middle. I mean, we can take all night on this, I'll just give you a brief summary. One of the problems in this whole country, and certainly Connecticut, is there is this huge gap between public housing and the private market housing. I did my master's thesis on a program in the city of Philadelphia that tried to address this. What was happening in Philadelphia was there's every housing authority, there's a maximum income. When you reach that maximum income, you have to move out. And what the Philadelphia experience was that people were turning down promotions and turning down raises. Because if they were expelled from public housing, there was nothing on the private market that they could rent. Huge gap. And this is very common. The idea of the missing middle is like 830G housing and other units. The 60% and 80% of median, I should have mentioned, the 60% of the median income in most of Connecticut is about $45,000 a year for a family of 4. The 80% is about $68,000 a year for a family of 4. These are not people on welfare. These are people with jobs, often more than minimum wage jobs. Whatever town you're from, take a look at what the secretaries in your town hall earn, the police officers, the snowplow drivers, the librarians, the teachers, the people that mow your lawn, the people that fix your washing machine, whatever. They all qualify for the 60-80%. I did an 830G in the town of Oxford, not far from here, and every single town employee, including the first selectman, qualified for the 60 or 80% median income. So again, these are the people that make your town or your state work. So you could zone for some higher density duplex, how we do it. Tiny houses, that's kind of all the rage now. As you hopefully know, Connecticut has for many years prohibited minimum house size. Your zoning regulation cannot impose a minimum house size. So you could have tiny houses, maybe you need to, but a tiny house doesn't make a lot of space. So maybe you want to make some regulations that reflect that. Manufactured housing, so mobile manufactured housing. Because it's made in a controlled factory environment, it can be produced for far less per square foot than stick-built houses. HUD adopted, the federal government mandated that HUD adopts uniform nationwide standards for mobile homes, such that now they're very safe and they're very energy efficient. But most towns prohibit mobile home parks totally. Inclusionary zoning H2I, let's talk about that a little bit. H2I of the statutes allows your town to adopt regulations that encourage affordable housing. For example, you could say, any subdivision over 10 lots shall include 10% of 14 restricted affordable housing, 80% median. Any multifamily development shall include 20% of deemed restricted affordable housing at whatever levels. Glastonbury just adopted this a few months ago for multifamily. They didn't do it for single family, which they should, but they did it for multifamily. So you have express authority to do that. And you can use overlay zones that allow higher density, again, if affordable housing is included, or again, density bonuses. I talked about H2I, so this is wide open. You can use any device you want to create or mandate a percentage of affordable housing. The statute doesn't give you a percentage. You use 20%, 30%, whatever percent you want to use. Another thing that's in H2I, you can use what's called the fee in lieu of. Stanford has made use of this. You might want to look at their ordinance. You can require a certain percentage of affordable housing, but the developer can basically buy out of that obligation by putting money into an affordable housing fund, which then will be used by, let's say, your housing authority to purchase units that will be used for affordable housing. The problem with this program, this concept, is that in many of the wealthiest towns, the fund never gets big enough to buy anything. Westport has this. Westport does have this program. And last time I checked, and maybe it's been out of date, I think they accumulated about $300,000 in their fund. And at $300,000 in Westport, they couldn't buy even one house, not even one condo, okay? So maybe they set their rates too low, I'm not sure. I know Stanford did use the money to create affordable housing in their city. It's a tool in the toolbox. I want you to be aware that it's out there. And I already mentioned you could require a certain percentage of development to be deep. The other thing, planning to action, okay? 830J, not G, 830J statute adopted in 2022 requires all towns to prepare a housing opportunity plan, a plan for how you are going to achieve affordable housing. They have to be approved by the Department of Housing. You have to implement the plan through your regulations, and you can lose discretionary state grants if you do not adopt the plan and the plan is not approved by the Department of Housing. Here again, there's always a disconnect between theory and reality. Most of the affordable housing plans that I have seen are just pablum. They say things like, the town shall pursue all available opportunities to buy. That's not a plan. That's eyewash. They were supposed to be a specific plan, when, where, how, but they tended not to be that. All right, we've covered housing opportunity from an income standpoint. Now we're going to talk about fair housing, which is different. What you've got here is, in 1968, we have the Fair Housing Act, the Federal Fair Housing Act, which said that you can't discriminate on the basis of race, family status, ethnicity, national origin, and so on. Buried in the FHA, or no one would ever think of it, is a provision that says that zoning shall not discriminate on the basis of race, ethnicity, and so on. Nobody gives that much thought. It's hard for any of us to imagine a zone that says it's for white people only, or no Irish or something like that. So even though it's in the law, nobody really thinks about it. It just seems obvious. Then in 1990, we have the Americans with Disabilities Act, which said that government, zoning, and other regulations, building code, must make what's called a reasonable modification. You've all heard the term reasonable accommodation. That is for public accommodations like hotels and restaurants. For you, as government officials, the optimal term is reasonable modification, which is to say, if there are any rule or regulation that you have, building code, health code, zoning, whatever, in order to accommodate the needs of disabled persons, you must make some modification. What happened in 1996 was that these two separate legal documents got married. The way they did that was in the list of things that under FHA, things you can't do, that you can't prohibit or regulate, they added disabled persons. So now you cannot have a zoning regulation that discriminates against black people, Irishmen, whatever, or disabled persons. And that suddenly made that buried clause a lot more important. So, you can't discriminate in sale or rental or otherwise make it available or deny dwelling to a buyer because of a handicap, because of the disability. And that discrimination may include your failure to make reasonable, again, modifications, not necessarily accommodations. Right? It's protected. We're talking about that. Race, color, religion, sex, music, national origin, naturally. And also past drug or alcohol addictions. Notice past. Right? All of you will face this at some point, I promise. Because a disabled person includes someone who is recovering from substance abuse, or someone who is mentally disabled in some way, recovering from it, the so-called halfway house is a home for disabled persons and therefore is protected by this FHA ADA combination. And you will get this. You will, in your community, you will have an application for some sort of home, residential facility for people who are disabled either by past drug or alcohol abuse or by some other factor. And you have to make a reasonable accommodation for those needs, however you do it. Not current users of controlled substances, not sex offenders, just as sex offenders. There's a great book, if any of you ever get a chance, it's called Scotland. It has nothing to do with the place with the plaid and the bagpipes. It's Scotland, Connecticut. The book is written by Gary Greenberg. It's about a quarter of an inch thick. And it's his experiences as a planning and zoning commission chairman where one of these halfway houses was proposed. And the residents were in fact mentally disabled, but some of them were also sex offenders. They do go together. And he was basically crucified for his role in that. But that does count as a disability. People who are threatened to health and safety, of course, are not covered, and transients are not covered. So a hotel can't come in and say, oh, you have to give us higher density or something because we may have disabled persons here. Right? So here's the basic of the exact language. No qualified person that is a disabled person shall have reason such as disability exclude for participation in or be denied the benefits of the services, programs, or activities of a public entity, that's you, or be subject to discrimination by such entity. Major life activities, eating, sleeping, bodily functions, communicating. If they manage their disability, they're still disabled. You don't get to say, well, you're okay because you have a motorized wheelchair. No, they're still disabled people. And this category of people who are regarded as disabled, I'm not quite sure what that means. The courts have been a little unclear about it too, but just be aware that it is in the Act. We're talking about recovering substance abusers, but they don't have to be in a program. There's no minimum time. You can't set a minimum time that they've been clean or sober. You can't say, we'll allow halfway houses in our town as long as they've been clean for 60 days. Right? If they declare themselves to be in a recovery program, that's it. And you can't, and families with children. Right? If you fail to make that reasonable accommodation, you can be sued by the Justice Department, and towns can have been sued, New Haven included, by the way. This disparate treatment. This is where your zoning doesn't actually say we don't allow disabled people. And by the way, I have seen zoning regulations that actually say mental hospitals are prohibited in this town, or convalescent homes are prohibited in this town. If any of your towns have that, get rid of it now, because it is flatly illegal. Simple as that. More common is disparate treatment, where the regulation doesn't say that, and it just says, for example, family is defined as no more than 3 unrelated persons. Most of these halfway house facilities have 6, 7 thereabouts with staff. They're always going to exceed your definition of family. You have to be ready to make a reasonable modification of that rule. It can include enforcement decisions as well as regulations. Theories of discrimination, intentional, rare. Disparate impact, very common. Refusal to make the reasonable accommodation, also very, very common. Many towns send these to the Zoning Board of Appeals. My personal recommendation is don't do that. Most CBAs are elected. It's a public hearing. The crowd will be there. They will be in a hanging mood. They will have their torches out. And the CBAs can have a very hard time saying, yes, the law is clear. We have to allow this facility in this neighborhood. I recommendation is to put in your zoning regulation provision that the CEO is authorized to make a reasonable modification for the purpose of compliance with FHA ADA. And if somebody doesn't like it, they can appeal the ZBA. Hopefully a lot of these will just go on the radar screen. Let's see. We talked about disparate impact. Policies that on their face and their lettering are neutral but have the effect of preventing persons with these disabilities. I served a 7-year sentence on my own planning and zoning commission in my own town, and the most controversial application we ever had was an Alzheimer's treatment facility, which surprised me. It was a special permit. The neighbors were vehemently opposed. It was so heated that at the night of the final vote, police officers had to escort us and escort the commission members to our cars, because people were waiting for us in the parking lot. And that's how heated it got. The fact of the matter is, the special permit, we can't deny housing for disabled persons, and certainly Alzheimer's qualifies as a disability. We can't deny just because the people in the area don't like it. That's not enough. If you do have an adverse or disproportionate impact, the town, municipality, has to prove that there's a legitimate public interest being served by that failure to accommodate, and that, my friends, is very difficult. Courts are not open to that. If there's certain costs to these modifications, you have to incur them. I'm trying to think of it. I mean, obviously, a public building, if you have to build a ramp, if that's what you have to do to make your town hall accessible, you guys spend. Well, we don't have the money. Well, to find it, you're gonna have to find it somewhere. People have to request the accommodation. You're not supposed to read people's minds, right? So sometimes people don't ask. If they do, you have to take action. This does not apply for the regarded as disabled category, and also we don't have as much trouble with that category. There is technical assistance available to you. This technical assistance manual, it does give you some ideas about how you can address the needs of disabled persons. It's available. I know that in Connecticut, the Commission on Human Rights and Opportunities has access to this. They will also help you. I will also mention to you that the Justice Department here in Connecticut has been very helpful in trying to educate people about FHA and ADA. We had this incident in Scotland that I talked about, and an attorney with the Justice Department came to Scotland and did a public presentation on the Americans with Disabilities Act, what it means to be disabled. He was there to take the slings and arrows, and he did a fantastic job. He wasn't afraid to go out and try to help people understand this. So the federal agencies and state agencies do want to help you. They don't want to sue you. They would much rather work with you. And as a town attorney, I have contacted them when I have a situation. They've given me a lot of help on what I can do and what options we've got. These are some ADA cases. I'm not going to get into these. You can look those up on your side if you want to. Fair Housing Act and zoning, how do they get together? For example, rules that exclude people with psychiatric disabilities, those are illegal. I already mentioned you can't have a zoning regulation that says no mental hospitals or no convalescent homes. That's clearly excluding disabled persons. Prohibiting group homes in resident zones, we absolutely prohibit them. You're already in violation of FHA. That's all there's to it. Using the family definition to keep those facilities out, it will not fly. So you have to find some way to accommodate the needs of disabled persons. There's things you can do to affirmatively help out, and I mentioned this, the regulation that allows the CEO to just grant these modifications in the office, the minimum of fuss and bother. That is about a 3-day course. A little over an hour. That does give us time for questions and answers. I'm open to whatever people just speak up. My hearing is as bad as my voice. Comments or questions, anything at all? Yes.
You listed many of the protected classes covered under the FHA and also obviously the Civil Rights Act. Is income level anywhere in federal law considered a protected class?
Not per se. As I said, there's a correlation between race and income. So if there's a disparate impact on a racial group through income, then yes. but there's nothing that I'm aware of that specifically prohibits. I have to say, I've never seen a zoning regulation that says in the zone A, you have to earn X amount of dollars to buy here or own here, but there's nothing specifically listed. Yes?
If there are 3 nursing homes in Woodbridge,
In a town, yeah.
how are the beds counted? Are they counted as units? How are they counted in the overall count for the population of Woodbridge? And how are they counted for the 10%? Does it go by each nursing home? Does it go by the number of beds?
The
Many of
question,
them are on Medicaid.
I'll restate the question. The question is for a convalescent home. How do the beds count toward the 10%? You're mixing 2 concepts. And I realize I covered 2 topics tonight, and probably I didn't transition clearly enough from one to the
No,
other.
I understand what you're saying.
Oh, well, the convalescent beds aren't units. They don't count toward your 10% at all. That's disabled persons. That's the Fair Housing Act side. But in terms of your affordable housing, a convalescent home, it is not a unit.
So it's taken out of the equation entirely?
Yes, it's out of the equation.
Oh.
I saw another, did I see another? I just said one here. Sir?
More of an observation, I think, like slide 42, where you were sharing interesting, creative ways to satisfy the affordable housing. At one point, we were about a tiny house, and then you said, does it make sense to put a small house on a neighbor lot? Well, I think something like that works for us in our solution, our watershed. What's wrong with putting a small house on a watershed?
The question is, I said it wouldn't make sense to put a tiny house on an acre lot, and the question is, why not? That would address some of the issues about aquifer protection and impervious coverage. Yeah, it's not going to happen economically. And logically, yes. Does Woodbridge have a minimum house size? I didn't think so. It's been illegal for years. So, how many tiny houses have been built in Woodbridge? None. Because nobody's going to pay a couple $100,000 for a house now and then put a 1,000 square foot house on it. They're just not going to do it. It sounds good in theory, it just isn't going to happen.
I guess I'm an idealist, sorry.
Sorry, what?
I guess I'm an idealist, sorry.
Idealism is a good trait, but you have to blend it with pragmatism. It's always that balance, it ain't easy. Other questions? Sir?
I would start by where you began, the fact that the 10% affordable housing has been on the books for 30 years.
Yes.
Were there any towns that took the initiative without more recent regulation requiring having something?
The question was,
Is there a model out there for Woodbridge?
the question was, I mentioned that this affordable housing law has been on the books for 30 years, and towns have had 30 years to deal with it. And are there towns that did take the bull by the horns and did take the initiative and did say, okay, how are we going to comply with this? Generally, no, but I will give credit to one town that and there may be others, but the one that I know about is North Stonington, Connecticut. Very rural town. They set up a housing committee, and for those of you who are on your housing committee, you should look at their report because it is really good. I was hired to review it, but frankly, they did all the work. I just reviewed it and I thought it was outrageous. It looks at all the available programs that are out there to provide affordable housing opportunity, and which ones, and by the way, North Stonington is mostly not sewer and water. There's a small corner of town, sewer and water, but most of it is not. It's generally a very rural town. And they really analyzed every tool in the box. A very good job. The other thing, for example, Old Saybrook. Old Saybrook has approved like 5 830G affordable housing developments without court appeals. They have a local housing sponsor called Hope Partnership that it's comprised of local people, Old Saybrook people, who proposed affordable housing in various locations, and they've been approved without, I wouldn't say without any controversy, but with really very little. And also, I mentioned the incentive housing, the 20% as opposed to the 30%. Any of you that are familiar with the old Seabrook Railroad Station, right next door to it, you will see a very attractive apartment complex. That was built under incentive housing. 20% of those units are deed restricted at 80% of income for 30 years. And it's a beautiful development. And of course, the location is perfect. Right next to the train station, walking distance to the town hall and the Stop and Shop. You know, it's a very successful example. The other thing I'll just mention is the town of Sherman has set up a nonprofit housing agency, housing corporation. And what they're discussing now is that the town owns a piece of property, and they're looking at leasing that property to the nonprofit housing sponsor at a reduced rent. Notice that means it's government money, right? Reduced rent is government assistance. That makes it assisted housing. That means that all of the units count as affordable. They all count, even if some of them are market rate. And they will be, by the way. They are talking mix. All of those will count. Glastonbury is doing this right now too. We're in the design stage in Glastonbury of 64 units. The town bought the land. The town hired the architects and engineers to design it. And it will be assisted housing in there, and it will be again a mix of market and below market rents. But all of it will count as affordable because it's government assistance is involved. So those are a few examples of things that are out there. Did I cover that? Right, next, sorry.
So, just in your experience, we're in the middle of having a lawsuit, being challenged in regards
Yes.
to what in your experience with respect to what have you seen in terms of the outcome of these types of things, and what could a common buyers do to try to mitigate that and take advantage of whatever opportunities there are to have the outcome come out of it?
The question is, Woodbridge is now being sued under a Fair Housing Act suit. What are things that Woodbridge can do? Well, first of all, what's my experience of the outcome of these? And second, what are things that you can do to address it? The case that's pending in Connecticut right now is based on a case called Mount Laurel. It came out of New Jersey. The Mount Laurel, very famous case. It was a Fair Housing Act case against a New Jersey municipality that was alleged to be using its own power to keep people with modest needs out. It resulted in a stipulated judgment that required all the towns in New Jersey to take specific steps to assure housing opportunity. I will say that most of these cases that are brought do settle in some way or other. There's usually some resolution at some point where measures are agreed to. And I suspect that's what will happen with Woodbridge at some point. You'll have to decide where does housing opportunity fit. And I mean, there's a lot of ways to skin this cat. I mean, I know, I was the fly on the wall during all those hearings here in Woodbridge. I was at every single one of them, so I know exactly what was going on there. And the proposal there was to allow multifamily, as long as it was on the minimum lot size, the same setbacks, the same square footage, the same coverage as any other single-family house. So basically, something that looked like a single-family house, but contained more families. That's one approach. Scattered site. A few here, a few there, you know, that's a way to do it. Another way to do it is like what Glastonbury is doing right now. We're going to buy a piece of land, our housing authority is going to develop I think New Canaan has an affordable housing, municipal affordable housing development under construction right now. It was under construction last year, it's probably finished right now. So I mean, there's a lot of, it's a matter of philosophy. Would you rather scattered site? Would you rather satisfy all in one or two locations? Frankly, I think both approaches have their validity. But I personally like scattered site. I can tell you one thing that the Glastonbury Housing Authority did years ago that I thought was incredibly smart. You know, every now and then we have these real estate booms and busts, right? And when you have a bust, there's foreclosures all over the place. What the Housing Authority did, I think it was in the 80s, Housing Authority went to foreclosure auctions on condominiums and bid on the foreclosed condominiums and won them. Became part of the Housing Authority staff. And the beauty of that is, your housing authority does not want to be mowing lawns all over town, one here and one there. It's not efficient. And in a condominium, all that's done by the association anyway. So these are units that look just like every other unit, surrounded by market rate units. Look the same, laid out the same, built the same. It's just some more owned by the housing authority. Right? That's a great, I don't know how many condominiums you have in your bridge, or how many things you can foreclose on, but you got to look for those opportunities when you could grab them. I think the thing that has never worked under these FHA cases is just stonewalling. Is just saying no, let the kid with the fingernails on cement, we're no. Then they won't settle, and the judge will bring the ballot down and rule that, all right, this is what you have to do. This is what's going to happen. Obviously, you want to avoid that. Yes?
Is all of Woodbridge on private wells and subjects?
I know that because I know Woodbridge has private wells as well. But
Is any of it?
remember, the proposal you had from Open Communities Alliance met the public health code. Those 6 units comply with the health code for well-separated distances and everything else. So that's not always going to fly. And the other thing is, of course, you can build sewers. When you build sewers for your high school, you extend them across the whole town for your high school. You can certainly branch off of that if you wanted to. You just haven't wanted to. So this new lawsuit may give you a little nod in that direction. Yes?
I wanted to clarify Mr. Norton's question, your answer to it. Were you saying that the towns you mentioned, North Stonington and Old Saybrook, they're not above 10%?
Oh, no.
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 Okay. I didn't
No.
think so.
No.
Because my understanding is that of the 169 towns in Connecticut, only 31 have achieved the 10% threshold, and it's primarily cities.
I don't know the exact numbers, but you're right. Most suburban and rural towns do not comply. The question that I was responding to was, can you think of other towns that have tried to be addressed this affirmatively? Towns that have tried to be proactive in it, and that's what I was responding to. A town like Sherman setting up their own nonprofit housing authority, Old Saybrook having a whole partnership, North Stonington studying different options, tax incentives, things of that kind. That's what I was responding to. Other questions?
I have one more, but I want everybody else to ask first.
I never know when I don't get questions whether I just covered it so well that there's nothing left to ask, or whether I've just lost you completely, isn't it?
You mentioned Shaka, you mentioned Shaka, that they had some.
CHFAs.
They use Shaka as a mortgage for DAP.
Yes.
Could they use another down payment assistance program, maybe one from Freddie Mac? Does it have to be Shaka?
The question was, to count toward your 10%, I mentioned the CHFA mortgages count. How about other programs that provide some sort of subsidized mortgage? The only thing I'm aware of is CHFA in Connecticut. But since we're talking about innovative ways to approach this, one of the things that I proposed last spring when I was town planner was that the town set up a mortgage fund where the town would loan people down payment money at zero or low interest, right, to allow them to purchase. Because usually the biggest problem for first-time home buyers is always the down payment. And after the real estate meltdown in 2007, I guess, they cranked up all of the requirements for home mortgages. One of the things that happened because of that I think was an unintended consequence was it made it almost impossible to buy a mobile manufactured home. All the new parks now are rental developments. And by the way, the developers don't like that. The developers would much rather sell the unit than rent it. But people can't buy them because the people that are eligible, the people that want that most are the people who qualify the least for private mortgages. So they turn it into rental communities. And similarly, anyone buying their first house, the the threshold to get a mortgage is increased. So anything you can do at the local level to provide assistance in that is also a plus. And you had another question?
I did. I presume you're aware of the new policy initiative announced by the Biden administration last week to encourage the conversion of or underutilized commercial and business buildings into affordable housing. Are you aware of any way that small towns like Woodbridge can encourage that, rather than, one of my major critiques of the affordable housing laws in the state is that I believe it's much too focused on new construction, and it's much more sustainable and ecologically sound to convert already existing buildings into the type of housing that we need, rather than destroying undisturbed land for that purpose. So I was very pleased to see this new initiative announced last week, and I was wondering if you had any experience with programs that focus on that, the conversion of non-residential buildings into residential.
So the question is, what about taking underutilized commercial buildings, office buildings and such, and converting them into housing rather than ripping up virgin land to create new housing? The focus is too heavy on new as opposed to adaptive reuse. I didn't know about the Biden administration initiative, but I do know cases where that has been done. In Stanford, they took an office building and converted it into not even, like 60% median, 50% median, very low cost housing. After COVID, office buildings are not filling up the way they used to, and more of us are working remotely. And so I know Stanford did that. In Killingworth, I'm counsel in Killingworth, we had an office building there where I think it was a 4-story building, and the owner of it asked to be allowed to use 830G to convert 2 floors of it to residential under 830G, and the commission approved it. A couple of years later, he came back and asked for the other 2 floors, wanted all 4 floors to be converted from office to residential, because again, a weak office market, especially Killingworth, it's kind of out of the way. And again, the commission approved that. There was no court case, there was no threat, it was just approved.
So you're not aware of towns offering incentives to encourage that, it's typically come from...
Usually for the developer, but I see no reason why you couldn't have incentives to do that. And because you're right, if you have underutilized buildings, for example, if they're historic, if they're old mill buildings, some towns have these old brick mill buildings, right? There are federal programs that give you incentives to revitalize and adaptively reuse those because they're historic structures. But a 1950s office building isn't eligible for that. So yes, you can, in your zoning regulations, for example, you could say an office building of larger than X, or of more than H, or just any office building, may be converted to residential, provided X% is deed restricted affordable. No reason you couldn't do that. Other questions? Yes. I'm sorry. Oh, accessory apartments, yes.
So the family had an apartment and needed it
Deed restricted. The question is, what if you have an accessory apartment that's deed restricted to an affordable family, but they only have a family member living there? Maybe they're not paying any rent, or maybe they're paying token rent. It still counts. It's a deed restricted unit. And it's an easy way. I understand that Trumbull, this was maybe 20 years ago, Trumbull, because of its proximity to a couple of big universities, they had a huge number of illegal accessory apartments. People had shoehorned them into garages and attics and basements and God knows what else. And so Trumbull gave a an amnesty program, create an amnesty program. They said, if you bring in your illegal accessory apartment, bring it to building code compliance, obviously you have to do that, and deed restrict it as affordable, we will approve it. We will basically validate it. Even though it wasn't illegal when you did it, it might not be legal today. We will validate that if you deed restricted it. And that plus, I think, one 830G development got them a moratorium. Because a lot of people came in to take advantage of that amnesty program and deed restrict. And again, I mean, I don't know how many of you are familiar with the man named Tim Hollister. He is certainly the dean of affordable housing in Connecticut, the absolute expert on the subject. He can't stand these accessory apartments being deed restricted because he feels, as I've said, that they would have rented at affordable rates anyway. And he's right. He's right. On the other hand, I'd rather see more units available than fewer. And if that's a way to skin the cat, I'm happy for it. I'm not going to. Yes, many towns it has to be a family member. That won't fly toward it. Yeah. And by the way, you also can't say elderly only. That won't count toward your affordable housing. It has to be available to anyone of any age, not a non-family member. And by the way, again, representing a lot of towns, we find that enforcing those family restrictions is just about impossible. You know, I've advised our client towns not to bother. What's this? You're going to go knock on the door, and you know, are you a family member? None of your business. I'm not going to tell you. What are you supposed to do, chicken? Where it's your game. You know, it's just not practical anyway. Yes, sir.
In terms of being restricted in the property, in the case of the ADU,
I'm sorry, deed restricting.
if you're deed restricting a property or to have a town, aren't you required to go through a market plan?
The question was, if you're going to deed restrict it, don't you have to have an affirmative marketing plan? You do for 830G. Okay, 830G requires that the affordability plan include an affirmative marketing plan, which is a marketing plan that is designed to reach underutilized populations, minority populations, low-income populations. But under 82I, which is the inclusionary zone, there is no such requirement. So if you're deed restricting accessory apartments, you don't have to require them to bring in an affirmative marketing plan. Other questions? Well, thank you for coming. You hardy people who came through the mist and the rain and a dark night. And I hope this was helpful to you and gave you some ideas and fomented some thoughts. And good luck.